All right. I am so excited for this special episode of Real Estate Fight Club. We are live today also, but we're actually also recording for a What Would You Do episode about when sellers lie on disclosures. And I have here with me today Rachael Real of Rachael Real Real Estate in Illinois. Hey, Rachael.
Morning, Jen.
Morning. And we have a special guest, Rachael. It is
Yes.
Heather Parker. She's an Illinois real estate attorney with Rosenberg and Parker. Hi, Heather.
Hi, thanks for having me.
We are so excited that you decided and could be on with us today because we have a lot of questions. Are you ready?
I'll do my best.
Let's do it.
So the biggest question and stuff that me and Rachael talk about all the time is the property disclosures, right? So I guess like the best place to start is there's so many questions, but start with like, what do we do? Like, what are they obligated to disclose? And walk us through the process.
Correct, yes. So the property disclosures are a document and a statutory requirement in most, if not all states. And in Illinois, it's a form document with a couple additions that have been added over the years that walks through a lot of representations about the real estate.
And allegedly, ... Yes.
The seller's obligated to complete those to the best of their actual knowledge of material defects in the different areas, such as the foundation, walls, windows, mechanicals, etc., as they're all enumerated in different.
So can we pause for a second? So you have actual knowledge and you have material defects. Can you dive into both of those quickly?
Absolutely. So an actual knowledge is something the seller actually knows in plain language.
Like knows or like thinks or like.
Right. It's the question we all have, right?
Yeah.
So actual knowledge, this comes up a lot, especially when they know that there might be mold in the attic, but they haven't gone up there, right?
Right.
Do they have to go up there and look and inspect it before? No. In Illinois, no, they don't have to. They don't have to investigate. They don't have to find out for sure. If they don't know that, if they haven't seen the water coming in the basement and seen their belongings being wet in the basement, they don't have actual knowledge of that leaking effect. So that's one area of a lot of interpretation, right? That a lot of real estate.
A lot.
Exactly.
What's the difference between a material defect and what's the other one?
Material defect.
Yeah, like what's a material defect? Like something you can't see, right? Necessarily.
A material defect is actually something that materially affects the health and safety of the occupants of the home, or something that have a material effect on the real estate value. So is a broken window thermal seal on 3 of the windows a material defect on a $500,000 home? Likely not, or maybe it is. That's something we never want to be in the judge arguing it.
Right.
So there's a lot of, you can get into the weeds with it. Is a $5,000 problem material for a $150,000 home, but not for a $700,000 home?
Right.
That's part of the analysis, but it's something that would adversely affect the real estate value.
Well, you know what, Rachael and I did
how does that differ from a latent defect?
Yeah, that was the other
there
word.
A difference?
Would be something that is just existing in there that not necessarily is known to someone. And that doesn't, the term latent defect doesn't refer to its effect on the value necessarily, or its severity.
Okay. And there's no obligation from a seller's perspective or an agent's perspective, at least in the state of Illinois, to be required to discover those latent defects, correct?
Not at all. No.
Correct. Okay.
Well, and Rachael and I did a What Would You Do podcast on, there was like a bus stop that was at the front of the house when the buyers looked, but then like by the time they closed, the bus stop got moved like a few blocks. And it's like, okay, it's not only about the house, but it could potentially, but for this buyer, that made a huge difference. That made them not.
That was a disabled buyer whose purchase was very much based on public transportation and the accessibility from the property.
Absolutely. And it was definitely material to that buyer's decision to buy the home. Whether it materially affected the real estate value as a whole, that would be something that would have to be decided by the courts, unfortunately.
Right.
Did the
Hence
seller
the
know that
multiple
was-
interpretations.
Right.
Right. Hence the everything's up for interpretation in these types of things.
Absolutely. In my community right now, they're redistricting some of the schools. And so
Oh.
a bunch of the neighborhoods are up in arms about some of the proposals. None are final. They're completely in conceptual frameworks right now. Does a buyer
Right.
on my street need to disclose that they might not be going to the high school across the street next year? I don't know
Wow.
the answer to that necessarily. It's public knowledge. But
Right.
would that materially affect the real estate? Absolutely, 100%.
I would argue
Depending on the
absolutely.
school.
Right.
Yeah.
100%. And it's not on the list of things that you have to
No.
statutorily disclose.
Right. Right.
What about, let's say, like in Ohio, and I think, I don't think it happens on the Kentucky disclosures, but in Ohio, it says like, it'll ask about disclosures of stuff that happened within the last like 5 to 7 years. So like, let's say if something happened maybe outside of that time frame and the seller like believes it to be fixed, but like maybe once the buyer moves, like it's not fixed, or like some situations like that, like the seller thinks it's fixed. What happens?
I think we see that a lot.
Yeah.
Frankly, we see that a lot.
Yes, and in Illinois, our statute, the actual law says that if the seller reasonably believes the thing has been corrected, they don't have to disclose. It's kind of a straight slam dunk, right? Your roof had a leak and you had the complete roof replaced it 3 years
Right.
ago. Since then, obviously you wouldn't disclose a roof leak. That doesn't exist anymore. That's a
Right.
cut and dry example.
Right.
But say you have 10 basement leaking cracks in your basement and you just go down there yourself and throw some super glue in there. Is that a reasonable belief that it's been corrected?
I mean,
I would argue no, right?
have you not seen the
Right.
commercials for that glue that like holds the boat together when you're in the ocean?
Right.
Come on,
Well,
Heather.
and what we think is a reasonable expectation of fixing a problem is definitely does not run along the same lines as what a seller feels like is an adequate correction of a problem.
Absolutely. And there's some case law in the statute here in Illinois that says that if the seller relies on a government authority, an inspector, a general contractor, structural engineer, that if you rely on a professional and it's an error, right? You have somebody out and they say that there's a structural problem, but it's a true inadvertent mistake, then that was a reasonable belief that it was
Right.
correct. Not something you would
Right.
have to disclose. I would argue if somebody had a concern about that, to just share that you had that concern, you had it looked at, and this is what the professional said. Obviously,
Right.
as a real estate professional, that'd be the best way to go so that you avoid those questions later.
Absolutely.
What
But
is
that's
your
kind of-
advice to sellers on, because I don't know about you, Rachel, but I have worked with some sellers that are like, they want to disclose just things that are like insane. Like if the toilet paper holder is loose, or like, whereas others are like, what foundation crack? What do you mean? You know what I mean? So like, what is your advice to us as agents to like help guide our sellers?
Correct. We've all encountered the nervous seller that literally wants to disclose, like you said, the loose toilet paper holder, or something that happened 20 years ago that has been long fixed and never recurred. And then there's the
That's
seller
more Team Rachel.
Yeah.
Yeah.
It's a huge structural concern and covers it up with a bookshelf in the area.
Right. Yeah.
Right.
Seen
All
it.
we can do is give advice. My advice always is with regard to what I would consider a material defect, and I would have that conversation with the client. I don't think the real estate value is going to be materially affected by whether that door latches properly or something like that. Nor do I think it's going to be affected by something that you already fixed 5 years ago. But that if it is something that is recurring, or it is something that would affect the value of the property, or honestly, that you think we even need to have a conversation about, the legal advice is to disclose it. Obviously, you don't want to have the risk. My job is to mitigate the risk for my
Right.
clients. So my advice would be to disclose, but they're always having to balance the risk of over disclosing, not getting any buyers in, not getting any offers on the
Right.
property because they've disclosed these minute details that never would even be considered a disclosure issue.
I wonder though, like, let's say that there was a foundation issue like 30 years ago, and it's like, it's been fixed. There's been no issues. You can't even really like see it anymore. Do you think that warrants a disclosure?
Under our statute here in Illinois, no. I mean, again, I guess it would come down to whether the fix was reasonable. If
Right.
it was just something that they ignored and it kind of went away.
The foundation issues never go away, Heather.
They had a contractor
It
out
just
and they
might stop moving for a
regraded
little bit.
Yeah, they regraded and an engineer redid it and the city approved the inspection and everything for it, then to me, that would not even be within the scope of a disclosure issue anymore.
Have you ever seen a seller over disclose where it came back and bit them in the butt?
We would
Where
probably
you've got
see
that,
that
like that
more.
engineer, you know, that engineer type seller who just wants slash
Right.
nervous seller who wants to really disclose everything. You ever seen that come back and kind of,
I've seen the other side more often, and I think that has
yes,
to do with when I come into the transaction, because
Yeah.
I don't get
Right.
involved until they're under contract, but I do have
Right.
clients that call me. Sometimes listing agents will have me talk to sellers before they list because they are concerned
Right.
about disclosing. And
right,
if it would, bite them later, it's because they wouldn't be getting any offers, or they
right,
Right. So we would probably see that more. I
right. Or
think
they may be making a buyer a little bit nervous by the fact that they've over disclosed or disclosed all kinds of minute things that really didn't have a value on the property.
yeah.
Correct.
It sounds like the advice is like, okay, if you were taken to court, could you reasonably defend yourself and say that this was not a material defect in the property, and or would 99 out of 100 people like look at your evidence that it was like fixed and agree that it seems like it should have been fixed according to your common knowledge of the issue?
Correct. Exactly. Was it a material defect? Did you have actual knowledge? Did you even know that it
Yeah.
existed? And did you reasonably think that it was corrected? So there's a lot more defenses to it, and there's a
Right.
lot of
Right.
information. So I definitely advise my clients. The risk is that the more immediate risk, and that happens more often, is not disclosing something, even a prior insurance claim, for example, that the buyer
Right.
discovers along the way, midway through the transaction. It's more to me about the transaction itself at the beginning, because a buyer discovers there was a huge water claim in the basement.
But in Ohio, and I believe, and in Kentucky, and I don't know about Illinois, but the clue report is the insurance claims report. And for us, that's a separate issue from the property disclosures. Is it the
Correct.
same in Illinois?
Yes. The clue report is something that some people pull. It's not a commonly pulled.
It's not commonly pulled here either, but when you go to get insurance and you find out that it's like sky high because of the property, not because you as a borrower, that's
Insurance claims are not part of our disclosures or the contract here.
maybe they should be. Rachel, add it to your list. I know you're on a war path.
It's added to
You know,
our review.
Our contract does have the stipulation of the paragraph in it that says if the buyer goes to get homeowners insurance and it's outside of standard market rates or standard appropriate rates, then the buyer has the ability to cancel that contract. So have you ever
Interesting.
seen that happen, Heather, with a
Yes.
particular buyer? Yeah.
Absolutely. And most buyers attorneys here include that in their attorney review letter, because we have a
Yes.
5-day attorney review period. So it's one of our standard requests, disclose any
Right.
insurance claims in the last 5 years. For us, it's to discover things like that, like our
Right.
with the basement, for example, but it's also to discover whether there was a huge claim for the roof that paid out 14 grand 2 years ago, but the roof wasn't replaced. So
Exactly.
that would affect the buyer's
Exactly.
ability to get a new roof, and also show that the seller was aware, or at least alleged, a material defect in the roof
Right.
Right.
when filing the claim.
Those
Right.
slippery sellers. Well, let's take a pause. I want to talk about two of our partners, and then when we come back, I want to talk about like, so what actually happens? Like, what are the trouble people are getting in, or if at all? Okay. So the two partners I want to mention today, the first one is Real Support Solutions. This is a partnership with, they do administrative, so they can do your transaction coordination, any admin help, they do training. And if you go to realsupportsolutions.com, you enter code Fight Club, you'll receive 3 hours of free training or $100 off your first transaction. And then I also want to talk about Ghost Poster, which is Monica's company, where she helps with social media posting. So she sends you social media post every day, and you can put it up so you can start getting clients off your social media. So you would go to mycoachmonica.com and enter Fight Club to get $50 off. So, all right, Heather. So what have you seen? Like, how do people get in trouble for this? Have you seen the realtor get in trouble too, is what I want to know.
So what happens when that seller who thought they were pulling a fast one on the buyer by not doing anything with their roof, only to find that the roof caves in after the buyer moves in, and the buyer then finds the receipt for the proposal for the roof repair in the bottom of the trash can outside when they're cleaning it out.
This seems very specific, Rachel. Yeah.
Yeah, that happened a couple of years ago, but I mean, there's the specific, the position where the buyer's the buyer's in the position then to know that the seller had actual knowledge. They could prove that they had actual knowledge because that receipt was stuck to the bottom of that trash can. They found it, and the seller insisted through the entire transaction that they had no issues with their roof. So you now have actual knowledge that the seller had actual knowledge,
right?
And the seller didn't disclose anything. So then what?
The very rare situation when we actually know that the seller knew that there was a problem.
That's the problem, right? How do you prove it?
Right.
We get calls weekly about post-closing.
Oh yeah.
Where people experience flooding the first weekend that they moved in, or sometimes people call that they experienced flooding 9 months later, and clearly it rained, in between then. Didn't flood. But most of the time, unfortunately, most of the time, which is why sellers do sometimes choose to play fast and loose. Most of the time, it's very difficult to prove that there was actual knowledge or that the situation existed before the closing. Things happen for the first time.
All the time.
Right.
Murphy's Law. It's a real pain in the what.
So I had a situation a few years ago where the air conditioner broke right after the closing, a week or two after, and they called the maintenance company who had a sticker on the unit, and they said, "Oh, we were just here 6 months ago, and we told them that they needed a new unit." So that's a clear case. Like, that's something where there's clear liability on the basis of the seller, and most attorneys, if we send a demand letter over, would say, "Hey, pay for this new AC so they don't sue you for attorney's fees and everything else." But that's extremely rare. It's extremely rare that there is evidence of the seller's actual knowledge. So it's hard. And when we're representing buyers, it's something to do, to make sure that we trust the inspectors that are going in. There's a lot of different avenues for a buyer to explore, whether there's liability under the disclosures, under contract law in general, because all of our contracts actually have representations about the real estate in it, separate and apart from the disclosures. So that's typically a longer statute of limitations for people. Or inspector liability, to go back to the inspector and say, "Why didn't you miss this?" Unfortunately, the inspector's contracts typically are limit recovery for they kind of CYA about everything. Exactly.
Well, I mean, so are the realtor, right? Like, there have been so many times where a buyer comes back to me as a listing agent, like, "Hey, this wasn't disclosed." And it's like, okay, I'm not a party of the contract. Like, you need to talk to your attorney. You need to talk to the, your realtor and see what they could do. But like you said, it's like, I mean, I don't know. The inspector, I can see they're supposed to find stuff, but they're also not perfect, right? Like, they don't, I mean, they're general.
Well, they can't see behind a wall. They can't see behind a wall. They're not allowed to take paneling down in a basement. As much as we'd all love to see what's behind the paneling, they're not allowed to do that.
Right.
So their inspection is limited in scope to what they can visually see and not what's behind a wall.
It's limited, and we've all seen, 3 different reports because of homes that go on that are completely vastly different, which I don't want to go off on a tangent, but a conversation I have very frequently with my seller clients after a deal cancels after inspection is, are the things that the inspector suspected during the inspection that freaked out the buyer, are those now disclosure issues for you?
Yeah, and that's a huge question.
Question they raise, now a disclosure obligation for you.
Right.
And it's not an easy answer, to be honest.
Well, what do you think about, I mean, in the last year and a half, the amount of people waiving inspections is like exponentially greater than my previous 12 years. What are your thoughts on buyers that have no knowledge of homes waiving inspections? Like, they're not investors, they're not builders, they're not anything. They're just
just trying to compete.
Right.
my thought is they shouldn't.
No.
It's one of those things like absolutely don't waive inspection. This is the largest investment you'll make. Yeah, sure, maybe you'll make an agreement to purchase as is, but you should know what you're getting into. And then
Right.
second,
Absolutely.
as a real estate professional, the attorneys, the agents, and everything, we need to advise them to do that.
And they
I
would
think
never
that's-
find a house, Heather.
I know.
They'd be moving in with you.
See, here in Illinois, it's interesting because, and I don't know if it's because we have attorneys involved from the beginning of every transaction, but
Right.
there's a lot of as-is contracts, but we haven't seen, I don't know if you have, Rachel, but there haven't been, it's pretty rare that we have complete inspection waivers.
Yeah,
Even
I've had a couple. I've had a couple
Yeah.
over the past, well, just in not necessarily where my client waived them, because I'm always recommending that they don't waive them, but we've lost out on multiple offers to buyers who have been waiving them.
Yeah,
Absolutely.
we have tons of them waived, but it probably
Yeah.
is because we don't have attorneys. Pros and cons, Heather. Me and Rachel didn't we do one on, oh no, that was me and Monica. We did a fight club on should you have attorneys or not involved in the transaction. I won't send that to you, Heather. You'll probably yell at me. Well, we really appreciate you being on. I know this podcast could have gone on for like another 10 hours or so, but
Easy.
Do you only practice real estate law in Illinois, or do you practice other states?
Just in Illinois.
Okay. And if people are licensed in Illinois or they have property in Illinois, what is the best way to get a hold of you?
You can call me at the office. It's 630-320-2068, or email me at heather@rp-legal.com. That's rosenbergparker-legal.com.
Awesome. And Rachel, if anybody has a referral for you in Chicago, what is the best way?
Chicago. My number is 630-542-8688, or you can find me on Facebook at Rachael Real Estate.
Awesome. Ladies, it's a pleasure. Thanks, Heather.
Thanks
Thank
for having
you.
us.